Well, it's lonesome in this old town.
You're listening to Where You Live with Gene and Tony.
I'm a face.
Welcome back to Where You Live. I'm Gene Sullivan. It's great to have you with us. On the show in just a little bit, we're going to have our friend attorney Dan Greenstein talking with us about a situation where two homeowners in Arizona are starting a class action lawsuit against no less than 27 property management companies because they say they are illegally practicing debt collection and breaking debt collection laws. And we're going to talk to him and get his opinion on that. But before we do, I want to let you know that we, of course, are broadcasting from the Natural Green Lawn and Landscape Studios. Remember, Natural Green is a locally owned and operated lawn and landscape care company. Their mission, to use the most environmentally sensitive products available to keep your lawn and landscape looking lush, beautiful, while still healthy for both people and pets. Now, whether you choose their organic program or their traditional program, rest assured, they're always using horticulturally sound principles for some great results. You can give them a call at 763-213-2410. We are also brought to you this hour by American Family Insurance, the Kim Bennett Agency, and Extreme Exteriors. You can count on Extreme Exteriors for expert installation of exterior siding, roofing, soffit, fascia, gutters, decks, windows, and more. With their knowledge and experience, they can design the perfect solution to make your home energy efficient, saving you maintenance and money for years to come. Give them a call, folks, at 763-441-1334. Tell them Gene and Tony sent you. And by the way, before we talk to Dan, it is now time, of course, for the CAI Minute from the Community Associations Institute, brought to you by New Concepts Rental Management. Whether you're an accidental landlord or a seasoned investor, New Concepts Rental Management can help you achieve your financial goals. New Concepts Rental Management can advise and guide you through every aspect of the business. Call Tony Crockett at New Concepts at 952-922-2500.
Are you a member of the Community Associations Institute? For nearly 40 years, CAI has provided education and resources to volunteer homeowners who govern community associations and the professionals who support them. Visit caionline.org to learn more. That address again is caionline.org. CAI helps community association board members by providing online resources, in-person training, and hard copy publications written by association management experts. CAI offers community managers professional development, networking opportunities, and a certification program that's established as the industry standard nationwide. Minnesota has its own chapter of the Community Associations Institute to bring resources and tools from community associations around the country right to your home. Visit CAIMN.com to learn more and become a member of CAI today. Your community and management company will benefit from your involvement. Join the Community Associations Institute today at CAIMN.com and click on Membership.
Well, our next story is about two specific homeowners, apparently in the state of Arizona. They have filed a class action lawsuit against 27 Arizona Community Association management companies. Their complaint is alleging that these association management companies are acting as third-party debt collectors, have engaged in unlawful activities in their attempts to collect past dues assessments from Arizona homeowners. Now, the plaintiffs also allege that these association management companies have and continue to pursue Arizona homeowners by charging collection costs and related fees that are not authorized by law. They are upset. They think that it is wrong that this is in the hands of association management companies. And so anytime we want to know information about legal issues, the person we always turn to is our friend of the show from Burnet Glifson, attorney Dan Greenstein. Hi, Dan.
Hi, Gene. How are you?
Good. Thanks for being on the show today.
My pleasure.
Now, let me ask you about this. You read this story. It seems a little strange to me that that an association management company might be considered
a debt collector.
Practicing unauthorized law as a debt collector. And I'd like to ask you about this. First, I guess let's set the background for our listeners. There are federal law that establishes what is a third-party debt collector and what they can do. Can you tell our listeners about that?
Sure, I can tell you a little bit about it. Our government was trying to put in place some help. I think this started back in 2003, 2004, and Congress was concerned about abusive collection agency tactics. And to remedy this concern, Congress passed what's called the Fair Debt Collection Practices Act, or sometimes referred to as FDCPA. And the act covers all types of consumer debt. So if a business owes you money, or it's a business debt, or if a business, let's say a corporation, owns a condominium or townhome, those debts are not subject to this act because this act only protects consumers. So that's number one. Number two, the purpose of the act is to regulate the conduct of debt collectors. And then they go into a long definition of what is a debt collector, but what it really comes down to is any person or group of people that regularly collect debts owed to others.
Okay.
So it's not a debt owed to them. If a company owes me, or if an individual owes me personally or my company some money, my actions are not covered by this act because it's my own debt.
So correct me if I'm wrong, but it seems to me that we're talking about a law that was established for the purpose of it's okay to try and collect the debt, but not overly strong-arming or trying to badger the consumer in a unorthodox or unethical way.
That is correct.
Okay.
And what the act does, it restricts these debt collectors from saying certain things to third parties about calling a relative, a neighbor, or the employer of someone who owes money, threatening them, calling them at all hours, the day or night, calling them at work, using obscenities, saying untruthful things, those kind of things.
Yeah. Now, what caught me interesting is that these homeowners in Arizona want to lump management companies in that category, but as I remember that you have taught all of us at New Concepts when you've been in, management company is looked at differently. Is that not correct?
Well, it is true in Minnesota. This is a federal law, so it's interpreted by the federal court districts. And in the District 8, which includes Minnesota but does not include Arizona, the courts have said, well, if the primary purpose of a management company is something other than the collection of debts, we're not going to consider them debt collectors under this act.
Okay.
And so most management companies in Minnesota, their primary purpose is to help administer and manage the association. And yes, as a part of that, they do some debt collection. They'll send out a notice or a letter to the delinquent homeowners, but it's not one of their primary purposes.
Right. And again, there's a special, different relationship with a management company because there is a contract where the management company has been asked to act as a fiduciary, to act as an agent for the principal, an agent for the association, and the role or position of an agent is to walk in the shoes of the association.
That's true, but not true. And like many of our laws, it kind of depends how you're viewing it. I'll give you an example. Any law firms that regularly collect debt, like my law firm regularly collects debt, we are subject to this law even though we're acting as the agent or representative for another party. So the laws are pretty clear that attorneys that collect debt are subject to the Fair Debt Collection Practices Act.
Okay.
Now, what I'm guessing is going on in this Arizona situation, I'm thinking that some of the management companies have taken it upon themselves to take over some of the debts, to say to their homeowner associations, assign this debt to us. We'll go collect it, and if we collect it, we'll pay you X percent of what's collected.
Yeah. Now, when they do that, they're clearly stepping into a different role than that of just being the managing agent.
Right. And I would wonder as well if some of these 27 community association management companies, that what they do is collect debt, and they're not out there helping manage associations. They're just going after the debt.
So then they would fall under the same rules as any third-party debt collector. So some of these things that they are alleging in and of themselves, let me ask you, something a management company can or can't do. A management company being able to appear in small claims court if they have a power of attorney.
Yes, a management company here with the power of attorney can go in and speak on behalf of the association.
Okay.
Now, the article doesn't specify exactly what they did, but it does say that they are practicing law without a license.
Okay.
And I wonder if they're going in and recording liens and bringing lawsuits without the proper documentation.
Sure. Okay. Another aspect in and of itself, negotiating an agreement with the delinquent homeowner on behalf of the association. That in and of itself is something that you could expect a management company to do.
You could. But I think there's a fine line there, because I think what the article is referencing is having these management companies have sole responsibility to decide what the settlement is going to be.
As opposed to trying to negotiate, knowing what the direction is of the board of directors.
Exactly.
Okay. All right. Interesting. It'll be interesting to see how this unfolds as this court case goes on. Dan, thanks so much for taking some time to be on the show with us today.
You're absolutely welcome.
Folks, that's Dan Greenstein, attorney with Bernick Lifson. We're going to take a break. Don't go away. A lot more of Where You Live after these messages.